Hey everyone, Harry here to talk about Donald Trump's appeal of the $454 million judgment in the civil case brought by New York AG Letitia James. This is back about 8 months ago now. It was a long-standing investigation, actually broken pretty much the sort of lead source of information, Michael Cohen. And the judgment finally handed down in February for $454 million. This is the one where, in order to appeal, there was a whole drama of trying to post a bond, which typically has to equal the amount of the judgment so that if you lose, it can be collected right away. Trump was able to to persuade the appellate division, which is the intermediate court in New York that the appeal is in front of, to cut him a break, a pretty substantial one, and post a bond of $175 million rather than the full amount. And there was side stories here about how he got it and who was the person who furnished it and why. But so that's the preface to this all. Now he files his brief. Second point, just quickly on process, is that the Attorney General, Letitia James, will file her response. Trump's appealing. She'll respond next month, and probably the oral argument will be around the time a little before the election, though one can't really expect the decision until after the election. Here's the main point. The third point that I really want to emphasize is these civil cases, they're big. This is by far the biggest, but you can also house within them the defamation cases, particularly if they concern conduct that wasn't while he was president. This is Trump Organization stuff. Remember that this is one reason why Weisselberg goes to jail, lying here about valuations. They're not going anywhere. So in different ways, because of the lucky break of Eileen Cannon and the lucky break of a ridiculously overbroad immunity doctrine and the lucky break of the Fulton County DA totally messing up her own case, all this criminal conduct has at best been held for now in abeyance. But this civil stuff is real. It's there, and it would proceed under this is the Clinton versus Jones case. So this is a really significant counterpoint to what's been a general theme of Trump maybe eluding once again. Okay. So let's talk a little bit about the substance here. And the main point is there is nothing new under the sun. All he is doing, Trump, is recapitulating arguments that they lost in front of Justice Arthur Engoron, who is justice here, it's New York, is the trial level judge who ruled against him. And this was his basic claim. It was really his sort of theme, but it just doesn't cut it. It's, hey, there were no victims because loans were paid back. Let me take a step back and remind you of the basic fraud scheme here. Take your properties and inflate their valuation, sometimes ridiculously, 500%. Really the most vivid, because it's so objective, is take your 10,000 square foot apartment and call it 30,000 square feet. What the hell? Why not? It's actually that and the lying about it that got Weisselberg his time in Rikers Island, his second time in Rikers Island. And do that as a sort of MO. This was Michael Cohen's point. You want to inflate if you're trying to borrow and make it seem worth more, and deflate for taxes perhaps or insurance, but basically, lying about valuation. So Trump says, hey, we may have lied about valuation, but it doesn't matter because we paid back our loans, so there was no victim. The banks did just fine, even though you can imagine in a world, and this is a very distant world indeed, but in a world in which Donald Trump and Trump Organization is fully honest, what would have happened? The banks would have said, "Oh my God, this is all your valuation. Here's the rate you're going to have to pay, not the big break that you got instead and did pay back." But the real problem with the argument, and I just don't see it, so basic. I just don't see it getting out of the box with the appellate division. This is under the code. It's a civil violation that the Attorney General brings because of the damage to the people of New York. The legislature has found, as completely constitutionally, so many states have it, you can't defraud when you're doing businesses like that. There's both a kind of intangible but also tangible harm to people of New York. If you got a much lower taxes you wind up paying, etc. So it is these civil case. The bank could have tried to sue for fraud, perhaps, saying we should have been paid more. But this is the people of New York. Letitia James, in fact, one of his big beefs is that during her campaign for AG, she made it fairly plain that she had him in the crosshairs if she were elected. But it just completely whiffs on the basic theory of the case, and Engoron made short work of it. I think the appellate division should make short work of it, okay? And that's the main claim. So in addition, sort of the next point is a grab bag of things. I believe we followed the trial pretty closely, that they all track things that Engoron, who's a very solid judge, did in the actual trial itself. So there's a whole statute of limitations issue. Some of this stuff was, fairly old, but there's a doctrine about a continuing wrong. That if the AG can show that the damage from the fraud extends and continues, then the statute of limitations doesn't begin to run until then. And that's a very fact-based thing. I think it's going to be hard to reverse. The basic, he says it 2 or 3 ways, is, Deutsche Bank, remember those guys? They didn't lose any money. The person, by the way, who green-lighted it, I think, lost her job, but didn't lose any money. And here's another big one. When we gave these valuations, we had disclaimers, like every single financial entity in the country and world, these may not be exactly right, blah, 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 and that is somehow supposed to be a get out of jail free. Well, I shouldn't say get out of civil trouble liability free, because they had that disclaimer. But of course, if that disclaimer worked, the whole law would be vitiated. You could lie all you want and then have a little fine print that says, I might be wrong here. Certainly don't trust us on this. Everything else really is secondary. Those were the 2 main arguments, except the award itself. So the award itself, which is a disgorgement award. So again, this kind of goes back to the initial theory. This isn't punishing him. This is the amount of money we determine you made and you have to pay back. It's a big, big amount. So something that I would not be surprised at is, he's claiming actually it's excessive under the federal Constitution. Even leaving that aside, courts of appeals will often conclude that awards are the subject of, or they were really driven perhaps by prejudice, or they're just too much. I think the fact that the Court of Appeals permitted Trump to post a bond of $175 million versus $454 million is a decent predictor that one thing they may do, one way that Trump may prevail, is for the overall award to be reduced. Remember, when we were thinking about it at the time, it seemed like that amount would literally wipe out all the cash of the Trump organization. So it's a very pretty penny for them. And that, I wouldn't be surprised, nor would it be so remarkable. I mean, it would essentially be a loss for Trump if they keep the liability verdict and cut the amount even in half. But it's a tangible possibility, and normally his arguments are lousy, and they should all fail. This is one that, given sort of practice in appellate courts, including specifically the appellate division of New York, you might see him catch a break in the bottom line. Those still would be a very hefty price tag, and one that he would have to pay. This is not a kind of pretend amount that you then go out and post a little. This is the check that he needs to write to the people of New York. I wouldn't be surprised if it's not $454 million, but I also wouldn't, or I would be surprised if it's 50 million. I think my best guess on this is his claims are not very strong on the law, but he's got something on the remedies, and that will be a serious possibility that the appellate division reduce that amount. Even so, at the end of the day, this is a punishing, difficult case for him, second only to being put in jail, and it's not the civil cases, including defamation. We're seeing this with other people too, like Rudy Giuliani. Don't go away even as the landscape is so much more unsettled in the criminal area. So this is real, continues to be real, and that's whether he's president or not. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.